Well, hello again. Last time we talked about the New York Times and what they did or didn't know about this sham lawsuit. Yes, I'm calling it a sham lawsuit. And today, it's not just my opinion. Today, I have a list of New York cases that back it up. We're going to talk about cases that were granted, cases that were denied, and a case that was originally approved and on appeal was denied. You will see a lot of similarities. You will also see case law, the very laws that will be used to determine whether or not this lawsuit was a sham. This first case we're going to talk about is a case that was actually granted. In this case, we're going to find some very important information. This was on May 2nd, 2018, and the case name is Lualdi versus T-Mobile. And the important thing about this one is this is also a Doe lawsuit. This is the way a Doe lawsuit is supposed to go. Everywhere from the adversarial caption to who grants the subpoena and the reasons why that's so. I think you'll find it very interesting. So let's talk about this case. So we have a consultant whose agreement with Lualdi had been terminated several months earlier. After that time period, there started to be unauthorized access to Lualdi's password-protected LAN. This information that's being collected is confidential. There are trade secrets. And that's what's being taken. Now, Lualdi's business developer, Alberto Pomelo, holds a meeting with an architect. Now, somehow Pomelo becomes aware that this consultant that had been fired months before knew about the meeting and the project specifications that the architect had provided. This covers some serious stuff, trade secrets. It could really affect a business if somebody else knows what you're building, at what price, and their competitors, they can underbid you, they can do all sorts of things. So this has to be dealt with. So they hire a service called Evade Solutions. They specialize in network security, and they run a forensic examination. They find the malware that's not only allowing someone in, but also decrypting passwords. There's another software called Wireshark, and that captures usernames and passwords on a LAN network. It accesses emails, but the important bit of this paragraph is that they're able to find the geo-IP logs, and from that the IP address. So this is all they have to go on to try to determine who's stealing their information. As they say here, petitioner contends that it does not have the identity of the person or persons without obtaining information and documents from respondent who can identify the individual account holder or holders corresponding to the originating IP addresses that appear in the geo-IP logs. Now, let's take a look at the caption and see what it's supposed to look like. We have a situation. Someone has accessed the account, they don't know who. So in the adversarial caption, notice there's 3 lines instead of the typical 2 lines. Someone versus someone. We have 3. And we see right away John Doe, but notice the plaintiff is listed in the matter of the application of Lualdi Incorporated. Notice this isn't a versus. Because why? It's an application. Keep that in mind. They're applying to the court for something. They're the petitioner. They explain what they're applying for an order pursuant to Section 3102C. This is very important. Of the civil practice law and rules to compel disclosure pre-action from T-Mobile USA Incorporated. So what does this mean, pre-action? It means before the actual lawsuit. So, they're not suing T-Mobile. They're petitioning the court to compel pre-action disclosure from T-Mobile. And what is it they want to know? The identity of the defendants. That's so far because they don't know the identity, they call them John Doe. This is proper. Now in Blake's, it was straight to a lawsuit to get a subpoena. That's not how you do it. This is how you do it. And you're going to find out why. But not only that, Blake was trying to get information that she didn't have that Stephanie Jones has. So just like this situation, Lualdi was looking for information that they didn't have that T-Mobile had. They needed information from T-Mobile just like Blake needed information from Stephanie Jones. This is how you're supposed to do it, to identify the John Doe. But this is not how Blake did it, because Blake knew exactly who she was targeting. She'd already seen all of those text messages. But even if she hadn't, if she just presumed that there were going to be text messages, this is how she should have done it. Not straight to Vanzan versus 10 Does. That's not how you do it. You start with this. And it should have been Blake, or Blakel, the corporation that she signed her contract under, not some hidden business that nobody knew of that had shipped some stuff from England one time, had nothing to do with her contract, had nothing to do with her movie, had nothing to do with Wayfair, didn't have contracts with any of these people, so could not claim any kind of harm. But it should have been her name or Blakel, the company, like I said, that she signed her contract under, petitioning, just like it's worded here, Jonesworks, saying, I need this information that I don't have that Jonesworks has, and petition the court for permission. Just like here, they know that this was committed against them. They just don't know who it is. They have an IP address. They need T-Mobile's help. Now, look who's speaking. Not an attorney, a judge. Judge Eileen Rakauer responds to this. We're about to find out why. By order to show cause and petition, dated November 19, 2017, Petitioner Lualdi seeks an order pursuant to CPLR Section 3102C for the issuance of a subpoena duces tecum. What is that? As all words in legalese are, this one is Latin as well. It literally means, you shall bring with you. It's a subpoena for production of evidence. This is the kind that Blake should have used. It goes on, compelling disclosure from respondent T-Mobile to provide documents identifying the person or persons holding the accounts used to obtain unauthorized and unlawful access to petitioner's computer network. So, Blake's should have had something like this. This petition tells you exactly what it's looking for and also why, and the why is very important. But before we get to that, notice it says there is no opposition. What does that tell you? It tells you that there can be, and we'll come across a case like that in a moment. But in this case, T-Mobile has no reason to protect anyone. They're happy to comply, and so they do. Now, had there been opposition, there would have been another step. So what does this tell you? If Blake had done it this way, had somehow gotten the court order, which I don't believe she would have, and we'll get to that, and served this subpoena onto Stephanie Jones could have opposed. She could have said, no, I have an NDA with this person. She used to work for me, and Wayfair used to be my client. I cannot give you this information. Then it would have bounced back to the court, further filings, further motions, further discussions, maybe a hearing, and ultimately the judge would have decided whether or not to force the subpoena. We don't see any of this with Blake. We just see this ridiculous lawsuit and go straight to a subpoena, and this subpoena did not go through a judge. If the New York Civil Code went through all of this trouble to outline all of these things, follow this regularly for cases that are brought to court, why would it be so easy to just sidestep this by filing a lawsuit and asking your lawyer to give you a subpoena before a judge gets to look at it, and then quickly close the case? Why would the court be okay with that when they've set up all of these fail-safes? Keep that in mind as we go through all of this. It says petitioner argues that the information it seeks from respondent is material and necessary to petitioner's claims. Petitioner contends that without the information, it will be unable to determine the identity of the person or persons who improperly and wrongfully obtained petitioner's confidential and or trade secret information. Furthermore, petitioner contends that it has a meritorious cause of action, that's very important, under New York law and federal statutory claims. And it states again there's no opposition. So what is meritorious cause of action? We know from the civil lawsuits that where in criminal cases we see charges, in civil cases we see causes of action. And it's a list of all the things that they felt were done against them that they're suing for. So all it means is that this cause of action that they have has merit. It's a legitimate cause of action, and that's important. And now let's get to what I told you we're going to get into, this CPLR Section 3102C, and it's listed right here. What does it say? It provides that before an action is commenced, in other words, before the lawsuit starts, disclosure to aid in bringing an action or to preserve information may be obtained. Here's the key. But only by court order. This is where Blake failed. This is where her lawsuit becomes a sham. Because she did not get a court order for her subpoena. Of all the ridiculous things in the world, only the Daily Mail has seen this subpoena. Team Justin's attorneys still have not seen this subpoena. And here's the thing, Blake doesn't have to turn it in until a minute before midnight on the day discovery is due. She can hold on to that as the last thing. She can hold on to it after that. And then they can draft a motion to compel. And after that, if she doesn't respond, then she can be sanctioned. But here's the thing, they haven't even gotten to see it. And until they actually have that subpoena, there's nothing they can do. I mean, if they went right now to the judge and said, hey, this newspaper in the United Kingdom has seen it, but they don't have a copy of it. They didn't show it to me, but they told me about it, and I want to take action against it. I mean, that can happen. They have to actually have this subpoena in their hands before they can do anything about it. So right now they're at her mercy. They just have to wait until she gives this to them. But we're told that subpoena has no court stamp. And now we know that it's true, because if she had filed a petition like this one before the court, it would be filed in the court just like it is in this case. And the caption would be like this one, and it would be responded to by a judge. But in her lawsuit, there are only 2 documents filed. There's the summons and complaint, and then there's the notice of discontinuance. But look at next to discontinuance, pre-RJI. What does that mean? An RJI is a request for judicial intervention. That's a request for a judge. So when you say pre-RJI, it means that the case has not even been assigned to a specific judge. It means this case is not being managed by the court at all. Nothing has happened. A document's been filed, that's it. And then it's closed before it ever even gets assigned to a judge. So if it has not been assigned to a judge, there's no way that a judge has reviewed this case, much less granted a request. But we know he or she didn't grant a request because there's no request filed. So according to the civil rules, you can get this pre-action, but only by court order. Why by court order? So that people like Blake can't come in with a sham lawsuit and get something they're not entitled to. You need a judge there to make sure that what is being requested is being fairly requested, and that the person that it's being requested from gets a fair chance to say okay or not okay. And what do we learn from the cited case here? Uden versus New York City Transit? Well, pre-action disclosure, and that's what this is called because no actions have been taken yet. And the whole purpose is that you need this information before you can go on with your suit. But while pre-action disclosure may be appropriate to preserve evidence or to identify potential defendants, and this preserve evidence, this could be if there's a chance that the evidence is going to be destroyed before the court can get around to it. So for example, say for some reason some evidence is about to be destroyed. Maybe it's some video from a company that every 30 days they wipe out their footage. So they can't sit and wait for the court to decide because by then it will be gone. It will be too late. So that's what it's talking about, to preserve evidence. Evidence that's in danger of being destroyed before they can get to it. Or to identify potential defendants, and that's a Doe lawsuit. You know something happened. You don't know who did it. It may not be used to ascertain whether a prospective plaintiff has a cause of action worth pursuing. So, this case we looked at, we know someone had invaded their computer. They had proof of it. They have the IP address. They just need to know who matches that IP address. So, that case passed all the standards. What about Blake's? Has she done any of this that she's supposed to do? Not one single thing. Let's look at this Uden case. And this gives you an idea of how strict this is. So we have Uden. She was waiting on the platform of a subway station. She falls onto the track and under the train, and she gets some pretty bad injuries. So while they're getting this case together, her counsel demands disclosure of the investigative file relating to the accident. And as always, when you ask for something, you can be told no. In this case, the New York City Transit Authority said no. So petitioner moved by show cause order for this pre-action production using this CPLR section 3102C. That court granted the motion. But now we're looking at the appellate court. They decide this was error. Now we might think it's a reasonable ask. So why did they say no? Because this code specifically states that it may not be used to ascertain whether a prospective plaintiff has a cause of action worth pursuing. It's not to be used for a fishing expedition. You can't use it for fishing. It goes on. A petition for pre-action discovery should only be granted when the petitioner demonstrates that he has a meritorious cause of action and that the information sought is material and necessary to the actionable wrong. And in this case, they felt the only purpose of inspecting the file at this point would be to explore alternative theories of liability, which is not a proper basis for invoking CPLR section 3102C. And why? The sentence before. Petitioner's notice of claim already set forth the time, place, and particulars. So that's how strict it is. Do we really think a judge, had this been done appropriately and been passed through a judge, would a judge have granted it? Because think about this. You already have to have a meritorious cause of action. Without the text that she was seeking, did Blake have a meritorious cause of action? Did she have any proof that anything had happened? No. She filed this lawsuit for a fishing expedition to try to come up with a meritorious cause of action. She did not qualify for this, and that's why her tricky attorneys did it the way they did it. Because had they done it this way, the court would have said, no, you don't have a meritorious cause of action. Come back when you have proof, and would have dismissed. How do I know? Let's review some more cases. This next case is Sandals versus Google. Now this one's similar to the T-Mobile case in that they have to request information from Google. There were some emails sent to undisclosed recipients. These people don't have to be named, they're not part of the lawsuit, but it appears to be to employees of Sandals in Jamaica. Now these emails contained articles from online and pictures about Sandals, and they were questioning why Jamaicans are not speaking up against Sandals, alleging that they were underemploying. So Sandals says, hey, this is defamation. We want to sue this person. But all they have in this case is a Gmail address. So they're trying to get the information from Google to know who they can sue for defamation. This one is so much like Blake's case. There's information. In this case, it's emails. But in Blake's case, she claims that she was defamed online. Untraceable stuff. These people want Google to help them find the person. Blake wanted JonesWorks to help her find the persons. But unlike Blake, they do it right. They request pre-action discovery. And we've seen what that looks like with the T-Mobile case. Now, just like T-Mobile, Google says, okay, we don't have a problem letting you know who this user is, but there is a stipulation that Google will notify the account holder of this proceeding and provide a copy of the order to show cause as entered by the court and the stipulation. So this is what was missing with Blake just putting out a lawsuit and a subpoena. She never did this properly because this is what a judge would have said. The person being served with this subpoena gets a chance to be notified. This is why you need a judge, to make sure this kind of stuff is done fairly and correctly. So this stipulation gives the account holder a certain amount of time to appear and contest the production of the pre-action discovery information. And guess what? The individual did contact the court. They said, we received your notification, but guess what? This email is not defamatory. It doesn't meet the criteria of defamation. This is what Stephanie should have been able to do. I'm not turning this information over because of this. But she didn't. She just handed it over. Because as we know from Leslie Sloan's big mouth, they'd already seen all this. And the only person that could have shown it to them is Stephanie Jones. So obviously she didn't have a problem handing it over. No doubt to save herself and also revenge. So they restate this law code, remind us it's only by court order, and the court says the purpose of pre-action discovery is to aid a party in bringing an action against a potential defendant. It's only to be granted where there's a demonstration that the party bringing such a petition, we've heard this before, has a meritorious cause of action and that the information being sought is material and necessary to the actionable wrong. And this is important. The merits of the cause of action are to be determined by the court. So, if Blake had come to the court, said, I want to subpoena JonesWorks, even if JonesWorks had said, yes, we'll cooperate with this, the merits of this defamation would have been determined by the court. So in this case, Sandals must demonstrate a meritorious cause of action sounding in defamation against the account holder for pre-action discovery to be granted. And then it goes into these factors that determine whether or not something is defamation. Now, we've gone over these so many times in the documents and the motions to dismiss and the memorandums back and forth. We know these by heart, but it says the court must first determine whether the statements of the account holder were those of fact or opinion based on what a reasonable reader would have believed them to be. And we have another list of those things. So this is what the court would have used to decide whether or not Blake's cause of action for defamation would have been met. But what did Blake have at that point to prove her cause of action? The situation with T-Mobile, that company, they had proof that someone had hacked into their computer. Blake had nothing. She had nothing to bring to the court to say she'd been defamed. The only reason she thought there was a campaign is because she had been shown these texts already in an illegal way. So she couldn't tell the court, oh, well, I've seen these. That wouldn't have been enough. She would have never met the standard had she done it this way, which is the only way you're allowed to do it. And let's say she had gone to the internet and found things that had been said about her, brought those to the court and tried to say, this is the defamation that they're doing. I need to find out who's doing this. The court would have had to decide whether or not there actually had been defamation. It would have had to meet this standard. So how did the court balance whether or not this was defamation in this case? They found that the emails contained protected assertions of opinion. The email does not contain assertions of fact, nor would a reasonable person construe that it does. Accordingly, Sandals has failed to establish a meritorious claim of defamation. What do you think Blake's claim would have been? Would it have held up to the standards for defamation? She had nothing at that point. But even if she did bring stuff from the internet and say it was them, look at this. Because the account holder provides links, the reader is in essence provided with the facts and can come to his or her own determination about Sandals. This indicates to the reader that the account holder's words are meant to provoke either thought or discussion and are therefore protected speech. What does that say about this alleged smear campaign about Blake? What sorts of things are they claiming were defamation? Were this smear campaign people taking her own words, video of her from previous interviews, linking them just like this, links and pictures, to provoke thought or discussion, protected speech. I believe this all came about organically, but even if it did come about as a smear campaign, what things were said about her online? She's rude. She insulted this woman with the baby bump. That's one of the things they claim was part of the smear campaign. Her saying what she said. Guess what that is? That's her own actions. It's a link to a video of her own actions meant to provoke either thought or discussion, therefore protected speech. People were talking about her ugly clothes. People were talking about her trying to sell her booze and her hair care. It was links to her own stuff to provoke thought or discussion and therefore protected speech. There is nothing about her claim that would have withstood this very first part. Nothing. So she did it in the way that she did, against New York law, boldly, brazenly, against New York law that clearly says by court order only. And you have to have a meritorious cause of action. She knew she didn't. She knew she wouldn't get the court order, so she just filed straight up lawsuit, got a subpoena, not approved by any judge because we saw a judge hadn't even been assigned. This lawsuit fails. It goes on, as the email at issue does not contain assertions of objective fact with regards to Sandals, the email cannot form the predicate for a defamation claim based on the first criterion stated above. Sandals offers no evidence of the harm the account holder's email has caused it. Sandals has failed to prove the fourth element of defamation cited above. Google shall not disclose the requested information relating to the account holder. Petition is denied, and this proceeding is dismissed. This is what would have happened if Blake had done it the right way. It makes me wonder if she did attempt it this way and did get it dismissed, and so she came back with the lawsuit. Or if her attorneys knew that this is what happened, because if those attorneys are worth anything at all, they know this. They knew it would fail this. So they did it another way. But guess what? They did it against New York Civil Code. Another case, Western Investment versus Georgeson Shareholder Securities Corporation. This was another application for pre-action discovery because that's how you're supposed to do it. They invoked this same code. It was denied. They appealed. This is the appellate court's decision. Also denied, because they said the only purpose of inspecting the file that they were requesting would be to explore alternative theories of liability, which is not a proper basis for invoking CPLR Section 3102C. It's not a fishing expedition. It's not supposed to be used to bolster your case. You're supposed to have a case with some missing information that you can only get through another party. This is why it's supposed to come through a court and a judge, so the judge can make sure that it's not being abused, because it's a very strict allowance here. As we can see in these denials, you might look at these and go, oh, no harm. They already have a case. They just need a little more information. No, the court says no. Start your lawsuit. Get this information in discovery later. You don't need it before to help you build your actual lawsuit. You have to come in with actual grounds, a meritorious cause of action. And if that gets accepted by the court, then you can request discovery when you get to that stage. But you can't use the court to go fishing. So as we saw in Lualdi, a Doe lawsuit, to get this pre-action discovery, it can be an important device for a litigator who represents a client with a meritorious claim and who needs the identities of the responsible parties to bring the action or information to aid in framing the complaint. But it may not be used to ascertain whether a prospective plaintiff has a cause of action worth pursuing. It may be used to obtain information such as the identity of an alleged wrongdoer that is material and necessary to the claimed cause of action. So these text messages that she got? Nope. They would not fall under this provision. Now that you've seen how particular the court is about these things, all of the cases that have come before these judges and these decisions that these judges have made. I only touched on a few for the sake of time, but once you start finding these cases, in the parts where they've been decided both in the regular courts and in the appellate courts, there are lists of so many cases just like these. So again I say, if they're this particular, if they deny so many of these things, why would they be okay with allowing people to use this loophole that they think they've found to just go and quickly, before anybody can notice you, file a lawsuit, grab a subpoena, no judge has even looked at the case, and you get what you need? And you think it's okay because nobody noticed you? Nobody saw what you did? If it were that easy, nobody would bother with these pre-action discovery petitions. Why would they? There's a risk of being turned down. This is not clever. This is not good lawyering. And I dare say, a court who regularly turns down these petitions is not going to think this is cute or clever or good lawyering. And if they let this pass by saying, oh, you got me, you pulled a good one on the court, they can surely expect loads of these in the future. So for all the blustering that Team Blake's attorneys are doing right now, they know they're wrong and they're probably scared to death. And what happened today? Blake just had to hire some new counsel. Now, it could be related to the Texas lawsuit with Jed Wallace, or it could be because she might be losing some counsel here from this little shenanigan. But either way, what they did is against New York law code. And this brings in my last episode with the New York Times. Did the New York Times know this was happening? Were they complicit? Were they duped? Did they suggest this? Did they see a subpoena without a court stamp? Did they see a subpoena without an appropriate lawsuit? There's a reason they used a CRD complaint and not the lawsuit that the subpoena that they speak about in their article. They say this stuff came from subpoena. They say that. And they didn't stop to think, if I had a subpoena from a lawsuit that was legit, that's my privilege to protect what I've written about. Why did they depend on the CRD complaint? They knew there was something fishy about that lawsuit and that subpoena. If I was a journalist writing something like this that was going to destroy some people's lives, I mean, she said a lot of terrible things about Justin, Jennifer Abel, Melissa Nathan, Jamie Heath, hurt them, hurt their families. If I was going to take that responsibility and print this in the New York Times, and I was told there's a lawsuit and a subpoena, first thing I would do is look that lawsuit up, look at that subpoena, take it to my legal department, make sure everybody agrees this is legit, check the filing, see if it's filed in the courts, and see the name Vanzan. What? 10 does. What? You want me to print this based on this? She had to have known if she saw that lawsuit, something was wrong. And she did, because she didn't use the lawsuit. She used the CRD complaint. If she thought that lawsuit was legit, she would have said, I'm protected because of this lawsuit. I saw a lawsuit. I know there was a lawsuit. I saw a subpoena. I know there was a subpoena. I'm protected, but that's not what she said. She said CRD complaint. And there's got to be a reason for that. And it points to collusion, points to conspiracy. Because there is no way, even me on my little YouTube channel, are going to destroy someone's life based on a lawsuit that says Vanzan versus 10 does and a subpoena that doesn't have a stamp. And if I go into the records, I can't find where a judge has signed off on it, because that should be filed. I'm not going to do it, even on my little YouTube. Why was the New York Times willing to do it? And if they didn't ask to see the subpoena and lawsuit, that's a fail too. That's reckless disregard, in my opinion. So the whole mess of them needs to answer for this, because they've destroyed people's lives over it. And their petition would have never stood up. A judge would have never okayed it. He never would have given them a subpoena based on what we see here and based on the New York rules. So, what now, Blake? This is Cassidy O'Connell saying stay well and stay tuned.